Welcome to this week's lecture. We're going to be covering three chapters with two videos. 30 and 31 will be the first video, and I'll do uh, 32, which covers limited partnerships and LLCs in a separate video because there's as much information in that one section as combined 30 and 31 have. So 32 will be by itself. But 30 covers formation and internal relationships or relations of general partnerships. And we'll talk about general partnerships, what goes into those, and a couple of other pieces with those as we go through this. Okay. So let's go ahead and get started. It is a little bit longer. I'm going to try to make these uh, as quick as possible for you so that you're not having to sit for, an hour and a half to watch a video. All right, so the topics for chapter 30 are factors affecting the choice of business association, the forms of the different associations. We'll talk about those. We'll mention some that we won't go in depth with on this. So some of the ones that I talk about as just in general, I'll say the name and maybe a couple points about it. There's not going to be anything more about it. You may see a little bit on it in the quiz, but it won't be anything that will be too difficult because there's not a lot that goes into those. They're real simple forms of a business entity. So those are easy to cover, easy to look at, and we'll go through as we do this. So a business enterprise can be operated or conducted as a couple of things: a sole proprietorship. You can have an unincorporated business association. That's your general partnerships or limited partnership. That is also a limited liability company or the LLC, which is the for someone who is not moving to the corporate level. They're not trying to start a corporation right off. An LLC is normally the preferred way to get going, especially if you have something. And I'll spend a lot more time talking about those in the PowerPoint that can covers those. But LLCs are normally the way most would go. But for the purposes of what a sole proprietorship is, that is a single owner or a married couple that start a business, normally under their name. There's most times with sole proprietorship, you may not have a fictitious name involved. Fictitious name is something that you do when it comes to banking purposes to make sure you're keeping everything separate. But with a sole proprietorship, it really doesn't matter because you do not have any protections in a sole proprietorship as far as limited liability go. All liability within a sole proprietorship rest upon the owners or the owner, that owner being a single owner or a married couple. Uh, for them, if they decide not to do the business anymore, they want to sell the business, that business no longer exists. It'll be a brand new business entity when a new person picks it up because it does not carry over into perpetuity. It is only for that person who started or that couple who started. If they bring anybody else in, they would have to move it to a partnership to do that. Sole proprietorship doesn't have extra owners. There's no way to really have it carry on beyond the life of the person who began it without changing the structure of it in some way. A general partnership is going to be at least two people, and sometimes you'll have a few more in there that are working, and we'll discuss general partnerships in a lot more detail as we go through these slides. Then you have a joint venture that can be between various parties. A lot of joint ventures are companies that get together to work on a problem. They're trying to figure out what they're doing. NASA has gone into joint venture with SpaceX, if you look at it in that way. Uh, there are others that for satellite distribution, they've done that. Companies will go into joint ventures together to develop software for vehicles or for computers or whatever they may need. That's the more common type of joint ventures now. Joint ventures used to be a company that was looking to develop property, do so on with a company that would do surveys and stuff, and they would do a joint venture where they came together. The joint venture lasts until the venture is over. So it could be something as short as a couple of months. It could be a couple of years, depending on how long it takes for that venture to end. A limited partnership is where you have limited partners that do not have a say in the day-to-day running of a business. Normally, limited partners are the ones who will they're funding. They have invested capital into or expertise of some sort into a partnership, but do not desire to be involved in the running of the partnership. So they go in as a limited partner, which means they're just there to get a return on their investment, whatever that investment may be. It could be property that they've put into it. It could be equipment they've put in to the partnership. So it depends on what their investment is as to how that repayment and the ending of their status in the partnership would be handled. Then we have the LLCs, then what is called an LLP, and then even further into the LLLP, which you may not run into a lot. And then, of course, corporations. Corporations they have expanded beyond the smaller version. An LLC can be up to they can have up to a certain number of members, and they can be ran. But once a corporation gets going, there's a lot more ways they can raise funds. There's a lot of things that go into that. And that will be next week. We'll talk about corporations. In the next module, we'll kind of, or in the next part of this module, we'll talk about corporations in a little bit more detail. And we'll spend some time talking about little pieces of how corporate business and corporate business law works for the most part, over the remainder of the term. We'll bring in protections, and we'll talk a little bit later on in the term. We talk about the protection of property and things as far as businesses go. So we'll talk more about corporations and build upon that. And it'll also build upon some of what we're doing here with the partnerships and then with the LLCs. The owners will determine what type of business they want to set up. All right. So it's up to the owners. An owner can, if they want to do it real simple, they do that sole proprietorship, and it doesn't cost anything for them to file their paperwork. It's real simple. You go on Sunbiz and you go through the process. You set up a sole proprietorship. There's no filing fees. There's nothing you have to do there. You just have to make sure you're maintaining your taxes and file them on a quarterly basis, or you can do it semi-annually where you're doing it every 6 months, or however you want to set it up. You can pay your taxes as long as you're getting your taxes paid in. And normally with a business, it's going to be your sales and use tax. Like in the state of Florida, you're required to file a sales and use tax every quarter, whether or not you've collected any tax or not. The one of the businesses that I had at one point that I used for purposes of doing videos and music for different gospel groups and ministers. When I would do that, if I did anything where I made money, probably the reason I don't have the business anymore is I gave away more than I brought in. But the business itself, on the off times that I would have a substantial amount of money coming in, I collected taxes. I had to make sure I set aside that money to pay those taxes every quarter so that I was not going to get in trouble, because just as you can get in trouble for not filing your personal taxes with IRS, you can do that with your business. So it's important to make sure that you have that. But I settled on real simple, a sole proprietorship, because I knew I wasn't going to turn it into something that was going to be larger later on. It was just me helping out some folks and doing that. And then once I was kind of done with it, I was done with it. And it changed kind of formation a little bit, but it stayed in that sole proprietorship, but it changed what we were doing with it. And eventually, just because of getting busy and other things, it went away. And it was real simple. All I had to do was just dissolve it. And there wasn't anything I had to pay off. Anything I owed, I paid out of pocket with it, because it was, I was liable for everything that was involved in it. If I needed to buy something, I paid for it. if someone was not happy with what went on with maybe a distribution or item that I sold to them, they took it up with me. There wasn't a corporation to take it up with. So if there was anything to be paid, I had to pay that out. So that was, kind of what I had to look at with a sole proprietorship. And that's kind of the reason that that's a good way to start, but not always the best way to go, depending upon what type of business you have. So part of what you have to look at when you're deciding and determining what type of business unit you want to have is what will you be doing? Uh, really and truly, what are you doing? Are you doing something that there's not a bit of liability involved? My liability for that that business was, making sure that I had my cords out of the way when I had cameras plugged in a auditorium or a um, inside a church or wherever it might be. As long as I had the cords out of the way where no one was tripping over them, had down strips or whatever, something to make sure that everybody understood it. That was pretty much the extent of my liability. There wasn't a lot. I didn't have dangerous equipment out. It was a camera on a tripod, and that was pretty much it. There wasn't a lot that went into it. Once I sold the recordings or the DVDs or whatever to the person, once they paid, they received all their items they were looking for, that transferred the liability to them because they were the ones now going to be selling that. I was not making it. It was not a viewpoint I had of anything that they were saying. It was on them at that point. So that liability transferred. So for me, having a sole proprietorship was not a deal breaker because there was not a liability I was taking on. Someone starting in lawn business may want to look at uh, whether they're willing to take that risk of busting someone's windshield or injuring an individual, rock slinging out from under a riding lawnmower is moving fast enough. If it was to hit someone in the leg, it could break a bone. So that's kind of one of those things to think about. If it'll shatter a windshield on a car or go through the window of a house, it can do damage to a human being also. So that may be a business where you want to think about, okay, let's spend the money and form an LLC. Some of the other factors or how easy it is to form that, your federal and state income tax laws, with a sole proprietorship and with the partnerships that we'll talk about with this video, your taxes, you're paying those. The owners are they're responsible for any taxes that come out of that business. It's what's called a flow through. It flows through the corporation to the person, to the ownership, and the ownership pays it. Once again, that liability is big. How much control you want over the business. The sole proprietorship has all control, all say, everything over their business. In a partnership, you begin to share that a little bit, and each step up the ladder on how an entity is formed, you're beginning to share in that responsibility. So it depends on how much control you want, how much say so you want over that. The transferability of ownership interest in a sole proprietorship that does not exist. Only under certain circumstances in a partnership would it exist, and in most cases, it just doesn't happen. And the continuity of it, the sole proprietorship, once that uh, founder is done with it and they haven't ever moved it into a higher entity, it is done, it's over with. Same way with partnerships. If they are not uh, looked at and, in some way made to be able to carry on, once the partner leaves, that partnership's done if there's not some interest in keeping it going with the other groups. So a partnership in general, the formation of it, it's association of two or more persons to carry on as co-owners of a business for profit. The one thing to keep in mind with all the versions we'll talk about with business entities here and moving forward is we're talking about all of these are businesses for profit. We're not discussing not non-for-profit or not-for-profit businesses. We're not talking about those. We're talking about a for-profit business. So whether it's that sole proprietorship, the partnership, LLC, whatever it may be, we are concentrating on a for-profit business entity. So keep in mind that all these will be something that's devised and designed to make money. So a partnership is two or more people coming together, deciding they have a common idea, a common thing they want to do, and they think they can pull all their resources together in a way they can make money, and they form a partnership. It's a legal entity. They have a legal existence separate from its members. It's how it shows. The Revised Act considers a partnership a legal entity for nearly all purposes. You will have a link. You already have a link, I believe. By the time this gets posted, you'll have that link in Canvas that will have posted to for the acts of partnership, the Partnership Act and the Revised Partnership Act. You should have those links. Go through to understand when it mentions Revised Act or when it talks about the Uniform Partnership Act, that you understand what those are. The partnership is a legal aggregate, a group of individuals not having a legal existence separate from that of its members. It considers partnership a legal aggregate for a few purposes. Your partnership agreement, this is where I'm going to spend a little bit more time. I'm going to skip to the second bullet point under the formation of partnership there. This is a way to think of what if. All right, so your partnership agreement is going to be where you decide what this partnership is, how it's set up, what are the who has what, who has brought what in, what's being done, how are things going to be paid once this is dissolved. You always have to plan ahead. Everyone who starts a business wants to think that they're going to be the next Walmart, the next Apple, the next Amazon. They want to be that to a certain extent. Some people want to start a small business and stay a small business, but they want that business to carry on. They don't want to think about it closing down and being done and going through that winding up process. Well, guess what? You have to plan for that kind of stuff. All right. So a big part of business law is planning for when you're going to need business law. So planning for when you're going to need to make decisions that are not the funnest decisions. Closing a business down, and I've been a part of businesses before when they were closing down, and there's nothing fun about that process. There's nothing fun about trying to liquidate your inventory. There's nothing fun about having to tell employees that they're no longer needed because, well, the business is not going to be there in about 2 months. There's nothing fun in that. So you need to plan on how that's going to be handled because you can have fun running a business, especially if it's something you're really into, you really enjoy. But if something happens and it's time to close that business for whatever reason, the fun normally ends at that point, and you're now having to deal with the seriousness of ending a business and paying debts and making sure that you've covered everything you need to cover, that there's not any outstanding issues that could come back and get you that could cause you to end up in litigation or anything along those lines. Your partnership agreement is designed to help you plan for that. It doesn't protect you against any of that. It just helps you plan for it. Partnership agreement is there to not required. Now, keep in mind, it's not required. All right. There's nothing saying you have to do this, but it is a best business practice, in my opinion. This is definitely my opinion on this, but it is a best business practice. And there is nothing wrong with setting up a partnership agreement because normally when you go into a partnership with someone, it's probably someone you know, probably someone that you have enough confidence in that you trust them. And they probably trust you the same. So if you set up that agreement between the two of you, it's going to be an agreement built upon trust to move the partnership forward, to make sure that you are working toward that profit in a mutually beneficial way. The partnership agreement will get you to that. That could be something as simple as what you're calling the partnership, all the way to how individuals who invest in the partnership will be repaid. So partners who put their own capital or equipment or whatever into the partnership, in your partnership agreement, you can cover how that's going to be handled at the end of the partnership. So those kind of things are real important to think about. The tests of partnership existence are a way that if there's some type of issue, that legal issue could come up, they're going to look at this. So is it an association? All right. It requires all these pieces to be there. An association, which is two or more people who have come together in legal capacity to agree to become partners. Legal capacity. Remember, we talked about that with contracts. That capacity, can they enter into an agreement, a legally binding agreement of sorts? Uh, is it a business for profit? And is there co-ownership involved? Okay, it includes the sharing of profits and the control of the business. Now, keep in mind, control of the business does not mean that your every hiring decision, every money decision, all that has to be talked out and decided. A partnership can rest upon the expertise of the partners. One person may be a great manager, the other person may be real good with finances. That great manager may be horrible with finances. You probably don't want them handling the books. So it's going to be decide upon the strengths of the individuals as far as the running of the business. Now, you can agree that all those kind of decisions are made completely with discussion, and it's only done by discussion. But most partnerships, someone's going to be a better manager. Someone's going to be better at keeping the books. Someone may be better at how to hire individuals, or they may be better at just the task of the partnership. Sometimes people enter into partnerships. If you see something moving behind me, I'm going to stop real quick. If you see something moving behind me, it is one of our cats. All right. So I don't have a growth on my shoulder. It is just a cat moving back there. But that one, I believe, is Two-Face. She's a tortie with a line down, and one side of her face is completely different than the other. So she got named after a Batman villain. Anyway, back to business entities and partnerships. Sorry for the sidetrack, y'all. But the co-ownership is more the sharing of profits and the control than it is of every duty. Nothing says that you have to share every decision and every task that is done. Tasks can be divvied out, and the best way to do that is upon the strengths of those that are partners and how they work within the system. Partnership capital is total money and property contributed by the partners. That is to be used by that partnership property, sum of all partnership assets, including all property acquired by the partnership. Those are pieces that have to be noted. That's important to keep track of, especially the capital, because once you get to that, if you get to that point where you have to do the winding up, you're going to need to know who's put what in, because that's how you end up getting a return on your investment. You may never collect anything. You may not collect a paycheck for the first little while, but you're going to, need to know how the capital is distributed. Hopefully you have capital left after you paid everything if you go through the winding up process. Let's talk about fiduciary duty a little bit. And this is something we've discussed a couple of times throughout the term. Once we're looking at these business entities, this becomes a more common thing that we'll talk about. So fiduciary duty among partners is utmost loyalty, fairness, and good faith owed by the partners to each other and to the partnership. What does all that mean? You do not take away partnership opportunities that could be helpful to the partnership and help with the profits of the partnership. You're not competing it in any way. You're not doing something that causes a conflict of interest, at least not without revealing it to the partners. All the other partners, they need to know if there's some type of conflict that arises. So a decision can be made among the partners as to how to handle that. Maybe you have to step aside from decision making for a little bit or whatever it may be, and not to reveal any type of confidential information within the partnership. All these things are so important because if a partnership is going to run properly, you need to have that type of trust. All those involve trust. Someone not appropriating partnership opportunities. In other words, not taking opportunities away from the partnership, not competing with the partnership, not being involved with conflicts of interest, not revealing confidential information. You want to be able to trust your partners in a partnership to do those things. All right. So you want to be able to trust them to not do anything that would harm. Duty of obedience in this is a duty to act in accordance with partnership agreement and any decisions properly made by the partners. The duty of care is owed by partners to manage partnership affairs without gross negligence, in a reckless manner, in any type of reckless conduct or intentional misconduct or a knowing violation of the law. So why are these important? The importance of maintaining this fiduciary duty, especially these pieces in that duty of care. All right. Liability. A partnership does not have limited liability. Violations of the law by the partnership, misconduct by the partnership, negligence by the partnership, reckless disregard for safety, those type of things by the partnership that can be tied to the partnership become the liability of everyone in the partnership unless you can prove otherwise. Now, individuals acting in a way that is not part of the partnership, that is handled on that individual basis. If they're doing something that matches that definition within the context of the partnership, they have now brought liability upon everyone who is a partner of that partnership. So that means your assets can be sought after. You can be sued along with everyone else. So making sure that the duty of care is there is a lot more important a lot of times than that duty of obedience. Partnership property, the right to use possess partnership property for purposes of the partnership exists with each partner. But note the for purposes of the partnership, transferable interest in partnership, a partner share the profits and losses and the right to receive distributions as part of that transferable. Partner may sell or assign his transferable interest. New owner becomes entitled to the assigning partner's right to receive distributions, but they do not become a partner. And creditors have a right to interest to whatever they need to come. They can place a lien upon the partnership. These type of things are normally what you see during the winding up process. So when that business is ending and we're going through the process of what happens, which we will talk about here in a few slides, that is part of these creditor rights and where that comes into and how interest in a partnership can be transferred. A chart that talks about the revised Uniform Partnership Act and the Uniform Partnership Act and how things change from one to the other. If you want to go through it and look at it, it'll probably help you understand that a little bit more. I'm not going to spend the time, going section by section on it, but it'll be good to look over. So I left it in the PowerPoint, and it is in your book. It just says RUPA and UPA in your book. It doesn't have Revised Uniform and Uniform Act. Distributions, transfer of partnership property from the partnership to a partner. Profits are distributed at equal share of the profits unless there's something else in the agreement. Back to that partnership agreement, there may be a reason that you want to divide up the profits of a partnership differently, depending upon how much a partner has put into it. Partnerships are not always completely equal from when they're beginning and how they're set up. Someone may put in more capital than the other. Somebody may put in more expertise than the other, and you may want to pay them for that. So that could be where your profits are different. If it's not stipulated otherwise, in other words, if it's not in that partnership agreement, the legal distribution of profits is equal to the partners. Capital, a partner does not have a right to receive a distribution of the capital contributions in his account before his withdrawal or liquidation of the partnership. Indemnification. If a partner makes an advance or a loan to the partnership, they're entitled to repayment plus interest. A partner is entitled to reimbursement for payments made and indemnification for liabilities incurred by the partner in the ordinary course of business. Then compensation, unless otherwise agreed, no partner is entitled to payment for services rendered to the partnership. So otherwise agreed. What are we agreeing at? We can split the profits up, but it's not necessarily a paycheck. So if we're going to do compensation, maybe someone is doing, we have one partner who is really, really, really good at keeping the books and they're keeping us out of trouble. They're keeping the IRS off of us. Maybe we need to put them on salary so they're making money with this. Each partner has equal rights to the management, but it doesn't mean that it has to be done that way. So there's that unless otherwise agreed. You'll notice that unless otherwise agreed popped up in a lot of these. Reason being partnership agreement. Okay. Otherwise agreed. Partnership agreement. You understand how important that is, I hope, by how much it just by design, it is going to be equal. It's going to be split. It's going to be unless otherwise agreed. All right. So you do not want a person who cannot manage their way out of a wet paper bag being in control of the management of a partnership, because guess what? You're going to be going through the winding up phase a lot faster than you thought. You're probably not going to get it completely unwound before you start winding it back up. So make sure that your resources are being used properly. Having a partnership agreement is another way to make sure your resources, whether it's those human resources or your capital resources, are used in the right way. Choice of associates. Under the doctrine of delectus persona, no person can become a member of a partnership without the consent of all the partners. That's just common sense that you vote. If you're bringing somebody else into the partnership, everyone needs to agree that this is a good idea, because you're probably going to run into a rift within the partnership if you do not do that. Enforcement rights. Each partner has a right without demand, notice without demand, to any information concerning the partnership and reasonably required for the proper exercise of the partner's rights and duties, and on demand to any information concerning the partnership. So you have the right to be able to see the books, to see those type of things without putting a demand on it. But there may be stuff that's still being worked on. There may be stuff in the books that, is that an accountant, whatever the reason may be. You may have to demand that you can see it. So those type of things are, how you get information, but you have a right to all the information involved in the partnership. As a partner, you have the right to all the information within a partnership. There should not be hidden information within a partnership. If there is, we fall back to looking at those fiduciary duties and which one is being violated. If there's key secrets being kept within a partnership, that means a fiduciary duty somewhere is being violated, and we need to figure out where that's at, because apparently there's a partner that needs to no longer be a partner in that instance. A partner may maintain a direct suit against a partnership or another partner for legal or of equitable relief to enforce the partner's rights. The partnership itself may maintain an action against the partner for any breach of partnership agreement or for a violation of any duty owed to the partnership. That's 30. 31. We were talking about the operation and dissolution of general partnership, in how to set up contracts of partnership, torts and crimes of partnership, notice to a partner, liability of the incoming partnership, dissociation, dissolution, and dissociation without dissolution. All right, a lot of terms and a lot that goes into this. So buckle up. We're gonna go through this and make sure that you get what you need out of it. All right, personal liability. Personal liability, as far as partners go, is if the partner is contractually bound, or if the partnership is contractually bound, each partner has joint and several unlimited personal liability. There is not a limitation on liability. Joint and several liability is a creditor may sue the partners jointly as a group or separately as individuals. If you ever wonder what joint and several means, that means you could be together or by yourself. Authority to bind partnership. A partner who has actual authority, express or implied, or apparent authority may bind the partnership. Any binding of the partnership needs to be done for the good of the partnership. Keep that in mind. Actual express authority is set forth in the partnership agreement. Any additional agreements among the partners or decisions made by the majority of the partners regarding the ordinary business of a partnership. All right. These things are important. I'm going to say it one more time, other than reading it, and try not to fall back on it because I said it so much for the previous chapter. Partnership agreement. All right. Keep that in mind. I said it twice. I know. Actual implied authority that is reasonably deduced from the nature of the partnership. How do you reasonably deduce it? By how it's being run, by how things are set up. Apparent authority is an act of a partner for apparently carrying on an ordinary course of the partnership. Is it apparent? And then we get down to estoppel. Sound familiar? A partnership by estoppel. It looks like a partnership. It smells like a partnership. It walks like a partnership. Guess what? We're going to think it's a partnership. Imposes partnership duties and liabilities on a non-partner who has either represented himself or consented to be represented as a partner. Where you get caught up in this, and it'll be catch you real quick. If you're not a partner to a partnership, but you go into a bank to help them receive funds, or you talk to investors to help them receive funds, and people think that you're doing it, and the only reason they give that money is because of your presence, guess what? You're now a partner, whether you wanted to be or not, because they considered you one. Torts and crimes committed by a partnership. Partnership is liable for loss or injury caused by any wrongful act or omission or other actual conduct of any partner while acting within the ordinary course of the business or within authority of counterpartners or co-partners. The partners are jointly and severally liable. We've already talked about this a little bit, and I told you how important the understanding the liability is. Breach of trust. A partnership is liable if a partner in the course of the partnership's business or while acting the same way doing that, they misapplying money or property entrusted by a third person. The partners are jointly and severally liable. Crimes. A partner is not criminally liable for the crimes of their partners unless they authorized or participated in them. That's where it breaks down a little different. All right. So all these, the torts, breach of trust, if they were doing something that had to do with the corporation, if they were working within or not corporation, but partnership, they're working within their partnership duties, then everyone's tied together and can be sued together or sued as a separate individual. In a crime, participation or authorization ties everyone else to it. Only participation or authorization. All right. There's a good way to look at that liability. Another little chart I left in here. Not sure why I did, but I did. That breaks it down a little bit more for you. And then notice to a partner that binds a partnership. A partnership is bound by a partner's knowledge, notice, or receipt of a notification of a fact relation to the partnership. All right. Once notification is given, what is a notice? A person has notice of a fact if the person knows of it, has received a notification of it, has reason to know it exists from all the facts known to the person at the time of in question. All right. So you know of it, you've received some notification of it, or it has reason to know it exists. All right. So that's binding in a partnership. Antecedent debts, the liability of an incoming partner for antecedent debt. So the partnership is limited to their capital contribution. So that's when you bring someone in to a partnership, a new partner, which in essence changes the partnership, but we'll move on from that because the book handles it a little different. When you bring somebody new into a partnership, their investment can be attached to any previous debt. All right. So any debts following that will be once again tied to them in that unlimited way as it is to all the other partners. So any debt at the point this partner enters into the partnership, if they're a new entry into it, they're not liable personally for any previous debt. Only to the extent of their investment, and then anyone in any debt incurred after they become liable for. Disassociation, a change in the relation of partners caused by a partner ceasing to be associated and carrying on of the business. Partners have the power to disassociate, but may not have a right to do so. All right. Term partnership, partnership for a specific term or particular undertaking. And then you have what's called a partnership at will, a partnership in which the partners have not agreed to remain partners until the expiration of a definite term or a completion of a particular undertaking. A partnership at will means you can leave at any point and we'll be done with you. Disassociation, wrongful disassociation is if it breaches an express provision of the partnership agreement. Y'all know I wanted to go back and harp on that partnership agreement again. Or in a term partnership, if before the expiration of the term or completion of the undertaking. The partner what triggers this, the partner voluntarily withdraws by express will. The partner is judicially expelled for misconduct. The partner becomes a debtor in bankruptcy, or a partner is an entity other than a trust or estate and is expelled or otherwise associated because of dissolution or termination as willful. Rightful disassociation is all other dissociations are rightful, including the death of a partner in any partnership and withdrawal of a partner in a partnership at will. And the effects of that, it terminates the dissociation partner's rights to participate in the management of the partnership business and duties to the partnership. If there's only two people involved, that also kind of does away with the partnership, right? All right, dissolution. Causes of dissolution. All right, the dissociation is a partner leaving. Dissolution is we're winding up. We're going to go in that winding up process. Dissolution by act of the partners. If it's a partnership at will, the withdrawal of a partner. Term partnership is the term ends. All partners expressly agree to dissolve, or a partner's death or incapacity, bankruptcy, or financial impairment, or wrongful dissociation if within 90 days after dissociation, at least half of the remaining partners choose to wind up the business. You get a little bit of option there. Any partnership and event occurs that was specified in the partnership agreement as resulting in dissolution. By operational law, the partnership is dissolved by operational law upon subsequent illegality. The court can order it. The effects of it upon dissolution of partnership is not terminated, but continues until winding up is completed. Winding up is that shutting it down process. Authority, a partner's actual authority to act for the partnership terminates dissolution, except so far as may be appropriate to wind up partnership affairs. Apparent authority continues unless notice of dissolution is given to a third party. Liability, dissolution does not in itself discharge the existing liability of any partner. Keep that in mind. Partners are liable for their share of the partnership liabilities incurred after dissolution. If you're going to shut it down, you better make sure everything's paid off, because if not, it's coming out of your pocket. That's what that says. You don't read it that way? That's what it says. All right. Winding up, completing unfinished business, collecting debts, and distributing assets to creditors and partners, also called liquidation. Any business that shuts down goes through a winding up process, and the term's pretty much the same, and the process that follows is similar. It's just how much the ownership is going to have to pay out is what changes. Partnership and the winding up, any partner who is not wrongfully disassociated may participate in it. The assets are distributed. All assets of the partnership include all required contributions of partners. The liabilities of partnership are to be paid out of partnership assets in the following order: amounts owing to non-partner and partner creditors, amounts owing to partners on their partner's account. All right, so the amounts owing to non-partners. There's a lot of things tied in that little group of words there in that little statement. Non-partners, amounts owing to non-partners. That's anyone that you have debts to. Best way to look at that. Any debts owed, that has to be paid before anything else is paid. Debts to partners in the partnership, that has to be paid. And then anything owing out after that, once everything else is paid to all the external, and if there is a partner that is owed then they're paid. Everything else gets paid after that. The Revised Act abolishes the marshaling of assets doctrine. All right, a partnership at will. The partner's death, bankruptcy, incapacity, expulsion, or termination of an entity partner results in a dissociation, but not dissolution. A term of partnership, if within 90 days after dissolution, fewer than half of the remaining partners choose to wind up the business, then the partnership will not be dissolved. And then any continuation after dissociation, they have a right to continue the partnership with a mandatory buyout of the dissociation partner, and creditors of partnership have claims against the continued partnership. Buying them out buys out their obligation. Keep that in mind. Disassociated partner actual authority to act. The partnership terminates. The parent authority continues for 2 years unless notice of the dissolution is given to the third party. Dissociated partner's liability to third person. The partner's association does not of itself discharge the partner's liability for a partnership obligation incurred before dissociation. A dissociated partner is liable for a partnership obligation incurred within 2 years after the partner dissociates unless notice of the dissolution is given to a third party. If you buy them out, you buy out their liability, then that can relieve them of it. But you have to buy out their liability from them. UPA defines dissolution as the change in the relationship of the partners caused by any partner ceasing to be associated and carrying on as distinguished from the winding up of the business. The original Partnership Act looked at it as once the partner leaves, it's done. Cause of dissolution under it is the act of the partners, operational law, or court order. Effects dissolution on dissolution of partnership is not terminated, but continues until the winding up of its affairs are complete. The partner leaving would trigger the winding up process under that, under the UPA. Winding up in that sense, liabilities of partnership are to be paid out in this order. Amounts owing to non-partner creditors, amounts owing to partners other than for capital or profits, loans or advances, amounts owing to partners for capital, and then amounts owing for profits. All right. So it was set up a little different. And then marshaling assets is segregating, considering separately the assets and liabilities of partnership and respected assets and liabilities of the individual partners. That applied only to situations in which a court of equity is administering the assets of the partnership or its members. Court of equity could be a court of bankruptcy, those type of things where someone legally is saying this is who we're paying and this is how we're going to do that. Under the UPA, the right to continue the partnership after dissolution, the remaining partners have the right to continue the partnership when the partnership has been dissolved in contravention of the partnership agreement. In other words, it went contrary to the partnership agreement, and the partner has been expelled in accordance with the agreement, or all partners agree to continue the business. The right of creditors of the old partnership may pursue their claims against the new partnership, and also may proceed to hold all of the members of the dissolved partnership personally liable, even the ones who had left. All right. That covers 30 and 31. A lot of information in those. All right, so we'll be back with another video. This one stayed under an hour. So I'll be back with another video just on chapter 32. So watch this one, take your notes. Until the next video, stay safe, study hard, y'all.